Okay, what I see on my screen is a void probate with a transfer on death deed. Is that what you see, Emily?
Yes, we're seeing that too.
Oh, good. That means we're all on the same page. That's great. Well, my name is Marcia Getting, and I'm the Family Economics Specialist with MSU Extension. And I've been working in this area of estate planning for many, many years. And it's just one of those topics that, particularly with things that are going on right now, people are interested in. And you've already heard from our co-host, that's Emily Stanley, and she's the one that does the background there, figuring out the technology part so that I can focus on the subject matter. So I'm delighted to have Emily from Fergus County, and she lives in Lewistown, for those of you that aren't familiar with county names. And then we have a webinar assistant too that is doing the pages for the webinar web pages and things like that, keeping us straight, and that is Carrie Hayes, and she's our assistant. Now, I'd like to extend just a really excited welcome to all of you. We have found now that we have over 140 people that have registered for our Tuesday tips. And I've got to admit, that's more than I thought, and it's great. And a special welcome to you Monk Guide Monday people who said that you want to learn more, and so you're tuning in 2 days in a row. We also have quite a few out-of-staters, and I'd like to give a special welcome to them. Welcome to our Tuesday tips. Now, last week I talked about enhancement tools, but I decided they really weren't enhancing, but engagement tools might be a better word for it, because we can use such things as Emily mentioned, the poll questions. So one of the things I'm curious about, are there any actions that you took as a result of last week's webinar? So maybe you talked to some friends, shared it with your spouse, significant other. I think the new term now is partner. Let us know what you did, and you can check there on the poll. And then if you do E, make sure that you describe in the chat panel. Let us know maybe what you did that we didn't think about listing you for. So this is our example of trying to get a sense of what is it that people do as a result of watching a webinar. So any feedback that you can give us, even if you think of something later in the day, that is just fine, or later in the day, later in the webinar, that is fine, and feel free to share that with us. Emily, do we have any responses? Oh, I see, now we do. Okay, we've got 20 of you at least that did not attend last week's session. So we know we've got some new folks, and we welcome you. And we see that the majority are sharing what they learned with others. And that's part of what we can do too. In an ordinary day, we'd be going out with and having coffee with someone, but not at this stage. Okay, so thank you very much for sharing that. Anything in the chat room, Emily, that we want to share with others?
Yeah, so we have some folks who said that they took some notes for future reference. And someone also mentioned that they did go to that Dying Without a Will website to determine their status.
Oh, good. Because that is a really neat experience to be able to answer questions yes and no, and then find out where your property is going to go. So share that with other people as well. Okay, what else have we got going on here? Well, we want to still encourage you to ask those questions. And for our new folks, that thing that you see on the right, I call it a flower. It's called a pine drop, and it's shaped like a question mark. And driving around, I had my husband screech on the brakes because I saw a question mark there and thought that'll be perfect for our shows. And one of the things that we've promised is Emily and I will remain in the WebEx room for 15 minutes after the meeting so that you have a chance to ask additional questions. Now I like to use wildflower tools as triggers. I guess I've reached that age where I need triggers to remind me to do something. And I also think triggers could be used to help you remind or help you remember some of the concepts that we talk about in today's program. And just to show you, this is an example. My husband, I had him title this one, and he said, Marcia in her Yellowstone studio. So that gives you an idea of sort of the makeup of using umbrellas, putting black velvet behind the flowers so that they show up in their beauty, absolute beauty. Now, this particular flower, those of us that live in Montana are excited to see at Yellowstone National Park, typically in May. And it's called a steer's head. And if you look real close, you can tell, yes, it is. Look at the eyes, green with a little red on them, and the ears are cool, neat flower. So I want to steer you today towards how you can use a transfer on death deed that's been provided by our legislature so that your transfer of property is going to be easier for your heirs, and it's also going to be less expensive. That's our main purpose today. And I had a question last time and through some of our meetings about, well, probate, what is it? And if we think of probate, it's a process, but also it's a process that involves fees. And if you appoint a personal representative, it could be a relative and they say, oh, I don't want any money. But typically there are personal representative fees. There's also attorney's fees if you hire an attorney to administer the probate. Then we've got copying fees, we've got court costs. And so here's an example of one that I calculated based on the value of a house. And that's how our probate fees used to be figured, at least until October 1 of 2019. So it was a percentage of the value that passes through probate. So we could look at this situation and say, here's a mom. She didn't do anything with the house as far as transfer on death deed. And so the personal representative could receive $5,400 and the attorney $8,100. And that would be over $13,500 just to transfer that home to the name of the heirs. Now, we can do that a lot easier now with a transfer on death deed. So that's what we're going to explore today. And that flower triggers me to say explore. So we've got a Mont guide, and I'm just delighted. We've had an opportunity to update that somewhat recently, and you would have that as a resource. That's one of the things that Extension makes available are Mont guides, so that you'll have a chance to read over the information that we're talking about today. And basically, a transfer on death deed is a way to convey real property. That's what we're talking about. It's your home, it's your land, and anything that's what they call affixed to the land. And what you get to do is designate your beneficiaries before you die. And then there's no cost of probate in this transfer. Now, a transfer on death deed became effective October 1st of 2019. Prior to that, we did have a law that was called a beneficiary deed. Well, I don't know why they decided to change the title. Perhaps it's because there's a lot of other states that have transfer on death deeds, and it's a more familiar term. Now, if you have a relative that you're talking to them about this and they go, oh my gosh, I filed a beneficiary deed, do I have to redo that? And the answer is no. Your beneficiary deed up to that time is just fine. What we call it now is a transfer on death deed. Now, the thing about having one of these deeds is you name someone, but they can't use your property as collateral for a loan. They can't sell your property out from under you. This beneficiary does not become the owner until you, the original owner, passes away. Okay? And we have a form. And the reason that Extension can have a form for a transfer on death deed is it was statutory. Anytime they include the name, that means that we can include it as a part of the extension offering for you. So if you scroll down to transfer on death deeds at that website, and we also have this available at the Tuesday Tips site. And the form is just actually pretty easy. You identify, the name of the owners, the legal description of the land. And now this needs to be the legal description. The description that you get in your property taxes, they have to reduce it because of this form that they have in their system. But make sure that you use a prior deed or something so you have the official. Then you want a primary beneficiary and a secondary, or in the law, they call it alternative beneficiary, and then have that form notarized. Then, after you pass away, this is what your beneficiary is going to do. The beneficiary takes a copy of the recorded Tod, that's what I call it, transfer on death deed, a copy of a death certificate, and at that point in time, the realty transfer certificate. Now, if you're sharing this with somebody that did a beneficiary deed, they're going to say, but wait a minute, I had to file that 488 form. Well, no, the property is not being transferred until you die. So there's a ruling for the Department of Revenue that you no longer have to file that form with your transfer on death deed. Now, where do you record this form? You record it in the county with the clerk and recorder where the property is located. Okay, so I'm in Gallatin County and I would file mine in Gallatin County. Now, some of you out there might be land barons, okay? So you've got land in Richland County, you've got land in Flathead County. Well, that means that if you wanted to do a transfer on death deed for each of those, you've got to file one in Flathead County and you've got to file the other one in Gallatin County. Or I'm sorry, Richland. Now, who can be your designated beneficiaries? Well, anybody that you want, basically. Your spouse is logical, your children, maybe you have some other relatives, siblings, whatever. How about some friends? Or they even allow a corporation to be a designated beneficiary. And then we've got lots of nonprofits out there. And so maybe the Bob Marshall Wilderness, the Yellowstone Forever Foundation, and maybe the MSU Foundation. Those are possibilities. So my Tuesday tip from an explorer's gentian is we're going to continue to explore if a transfer on death deed is really something that you want to explore further. Now, here we have a foxglove. And when I was giving public meetings, it was really fun to put up a photograph like that and see how many in the audience would know what kind of flower they were. And it was always fun when you've got a biologist or one of those a botanist, and they would know every one. Whereas the rest of us are going, oh, that's new. Well, this foxglove, well, yes, it does remind me, certainly we've gotten acquainted with gloves in this era, haven't we? But this is better. This is going to perk us up. These are a couple of foxes that I saw in the Beartooth Mountains. And I had a brand new camera that was telescopic. And so I was trying to get up close to those. And I just loved this photo. So I thought, of course, I've got to work it in. But maybe I'm getting off track here. Let's get to the subject matter. Okay. Outfox the law. Yeah. Let's look at what if you designated a beneficiary and they die before you do because you only did one. Well, you need to be foxy and specify a successor or an alternate. So this is what Mark Fox has done. He has recorded a transfer on death deed. And what he's saying is, I want my son Evan to inherit when I die. But if Evan dies before I do, or if Evan is in the same car accident, I want it to go on down to my grandson, Luke. Okay? And you're not limited to just one designated beneficiary. You could have successors and have 2 or 3 or more, whatever it is that you want to do. Oh, Somebody snuck that in there. Emily, was that you? I wish I could hear a little laughter. I missed my public meeting, so don't you, Emily? Okay, onward. Tuesday tip from the Foxgloves, and that's outfox the law by naming a successor beneficiary. Okay. Now, these are tiny little flowers that are about like this, and they kind of grow in a mat. But it's always so exciting to be able to get the hairs on these flowers. And that's something I simply did not realize is how hairy flowers are. But these are called twin flowers. And that makes me think of situations where you may want to name multiple beneficiaries and maybe they're twins. So, Emily, let's say that you want to use your Todd to leave property to several designated beneficiaries. What happens?
Well, let's take a look. So, in the title of your property, you can specify the form of ownership for your designated beneficiaries. And there are a couple of different designations you can make. Joint tenancy with right of survivorship or tenants in common. And we'll take a look at what each of those terms mean. So, for example, if your title reads that the beneficiaries will be joint tenants with right of survivorship, this is an example that we might look at. So let's say that Pat owns a piece of property and his siblings are Faye and Ray. So in Pat's deed, he has a transfer on death deed that says if he passes away, that his beneficiaries Faye and Ray will receive that property in joint tenancy with right of survivorship. Well, let's say that Pat does pass away, so that property is passed down to both Faye and Ray. They are both owners in joint tenancy together. So after Pat dies and that property was passed to Faye and Ray, just a couple of years later, Faye passes away. So Ray is the only one left, and he is Pat's brother. So our question then is, who receives Faye's share? So remember that Pat passed away first, and then that property went to both Faye and Ray in joint tenancy together. So let's say that Faye passes away. We want to know who is going to receive that share that Faye had originally inherited from Pat. Is it going to go to Faye's one child that we see there in yellow underneath? Is it going to go to Ray's kids, those two children in purple underneath Ray's name? Is it going to go to Ray, or is it going to be turned over to the state of Montana? Keep in mind that when you answer these questions, you are not being graded on them. We don't even really know who answered them. We just want to see where we might need to do a little bit more explanation, some concepts we need to clarify. So I would encourage anyone who has the ability to answer those polls to do so, because it really helps us figure out what we need to go over.
And I'll throw in, don't forget to hit the submit button at the bottom of the page. When Emily and I were practicing this, I didn't see it way down there. So you do need to figure out what answer you want to give and then go down and click on, I say hit, click is better. Click on that.
Okay, let's see our answers. We had 27 people say that Faye's child, that child in yellow, would receive Faye's share of the property. We had just 3 people say that maybe Ray's kids would receive it. 21 of you said that Ray would receive it, and we had no one answer state of Montana, which is good because definitely doesn't go to the state of Montana. And then we had some folks who didn't answer. Well, let's see what the right answer was. So most of you answered that that property would actually go to Faye's child, when in reality, it will go to Ray. And the reason for that is because of the joint tenancy in common with right of, not in common, joint tenancy with right of survivorship. So then let's say that Pat has designated Faye and Ray as their joint tenants with right of survivorship. They're both the designated beneficiary, but let's say that Faye and Ray pass away before Pat does. What happens to the property then? So this is one of those examples where Pat may have put a successor beneficiary on his TODD, and maybe it said something like, if both Faye and Ray predecease me, the Montana 4-H Foundation will become the successor designated beneficiary effective upon my death. So in this instance, that means that the property would be transferred to the Montana 4-H Foundation because Faye and Ray were both not around when Pat passed away to receive the property.
And there's a thought there that maybe Pat could have redone it and had, you know, some other people before it went down. Isn't that right, Emily?
It's true, right. So if Faye and Ray both passed away and, you know, he has Montana 4-H Foundation as a successor beneficiary, but if in the meantime there was another person he would have rather had, he certainly could have changed the TODD to say that.
Okay, well, Emily told you about joint tenancy, and I'm glad that she asked that question because so many of you just made the assumption that it would be the daughter that would, you know, or the child would receive that. So now let's look at another way that we can title property. And across Montana, when I ask how people have property titled, I find joint tenancy with right of survivorship is the most popular. And there are people that have tenancy in common, but honestly, I had never heard of it until I started working in this estate planning area. Because with a tenancy in common, each individual owns an undivided interest in the property. So if we had a house and we had it as a tenants in common, we don't draw a line down the center of the house and say, well, Marcia owns this side and Emily owns the other side. Or if we had some land out there, it'd be the same thing. We don't draw a line and say, Emily, Marcia. It's an undivided interest in the value of the whole thing. So now we've got three siblings again, and we have Edna. And Edna is the owner of the property, and her siblings, twins, twin flower, Cody and Brody are the designated beneficiaries. But in this case, the property was titled as tenants in common. So we see that if Edna does die, well, the first part of it is the same as Emily's joint tenancy. It's Cody and Brody each receive 1/2. Okay. Now, let's say that Edna dies and then Brody dies 2 years later, and Brody didn't have a will. Okay. So what we want to know now is what happens to Brody's share. Okay, so we've got Brody's kids, we've got Cody on the other side, the twin, and we've got Cody's child. So which of those three do you think is correct?
So keep in mind that with the last question, the reason why the other brother received the deceased brother's half of the share is because it was listed as joint tenancy in common with right of survivorship, which means that whoever passes away first, full ownership will be moved over to the person who's still alive. But this one is tenancy in common, which is a different designation.
Yeah, and I'm going to jump on you a little bit there, Emily. You do, like some of the people, they say, well, it's joint tenancy in common. No, it's joint tenancy with right of survivorship.
Thank you. I caught myself saying that one time and then I did it again.
Yeah, and that's okay because teaching opportunity here. Okay, what have we got in responses from folks? Okay, so we have 31 of you say it's Brody's children, and we have 16 that say it's Cody. Okay. Those of you that said Brody's children are right. See, that's the feature of a tenancy in common. You have an undivided interest, and you can will that undivided interest away. Or if you die without a will, then it's going to go under the Montana law of intestate succession. That's a fancy name for it. So we see in this case, because it was tenancy in common, we've got Brody's children splitting that interest. So now what we've got is a 50% undivided interest that's Cody's. We've got 25% for each of Brody's children. So that is the major difference. And when you have joint tenancy versus tenancy in common, it impacts where your property is going to go upon your death. Okay. Now, we've got the same situation that we had before, where maybe Edna is thought ahead and she said, well, you know, we often travel together at Thanksgiving or something along those lines. Maybe I should have a successor. And so she did the same thing, and she decided that she wanted her share to go to the Montana State University Alumni Foundation, effective upon her death. Now, of course, if I was giving this program in Missoula, do you think that I would say the Montana State University Alumni Foundation? Well, I might if I was just trying to aggravate the audience there, but anyway, that's what you can do. Figure out who you want to be your beneficiary. And I would say that would be true of all things. You may say, well, of course I want my sisters to get it, but let's just say they're not alive at that time. Well, always name a successor and you decide who that's going to be. Now, so the summary of this is how your beneficiaries receive that property depends on how the owners convey it. So that is one of the considerations. It's just not filing a beneficiary deed. You've got to think about how do you want them to receive that property. Joint tenancy with right of survivorship. Now, everybody say that after me. You too, Emily. Joint tenancy with right of survivorship. I didn't hear you. Let's do it one more time. Joint tenancy with right of survivorship. Okay. Or tenancy in common. And we got to get that in the brain of what those two are so we can make a decision on how we want our things. So if you have multiple beneficiaries, we want to decide on those two methods and see which would be best for our situation. Oh, these are beautiful alpine forget-me-nots. That means I don't want to forget to tell you about married couples and thinking of your children. And how do you do this type of thing? Well, I've got this married couple, Doug and Laura, and they have 2 daughters. Okay, and what Doug is thinking about is if I die, I want the property to go to my wife, Laura. Okay, so they've got it in joint tenancy, and she's going to get it anyway. So if they both signed the Todd, and they're both in an accident there where they both die, then it would automatically go then to the 2 daughters. But in our prior example, you see Doug dies because it was the joint tenancy that takes on first and it goes to her. And then the Todd would have come into effect if both of them died. And that's why we have this one. So we've got the daughters. Now you might be in a situation where you need to think about that all owners need to sign it. And here's an example of where that was not done. I've got Patrick and Lynn. They have the property in joint tenancy with right of survivorship. And Lynn, on her own, decides, well, I'm going to file a beneficiary deed. I went to Marcia Getting's presentation, and she stopped listening at this point. And what she does is name her daughter as a designated beneficiary, thinking her share is going to go down to Lynn, just like many of you did on that other example. And you see what happens is if Lynn dies before Patrick, well, he's going to get it because it's the joint tenancy. The daughter of Lynn does not receive anything because Pat didn't sign the transfer on death deed. So we've got some issues here with Pat. We don't know him very well, but the first thing that might come to our mind is, well, is Pat going to honor Lynn's wishes? Will he file and record a Todd naming another relative, perhaps a partner, a charity or nonprofit? And you see, then Lynn's daughter would not receive it. So it could be in that kind of situation that Lynn and Patrick need to get together and decide, well, is the best way for us to do this a transfer on death deed? Or maybe do we want a will and put some parameters in there, some other kind of thing? But it's something certainly to discuss. So a Todd should be signed by all owners when you have that property in that joint tenancy. Now, Emily, what happens if you file more than one transfer on death deed?
Well, let's take a look. So this isn't, if anybody knows what this flower is, it's an evening primrose. So we're going to talk about the primrose family. For example, let's say that Evan Primrose files a transfer on death deed in 2020, and he designates the beneficiary as Susan Primrose. But then, let's say that later, Evan Primrose decides to file a transfer on death deed for the same piece of property in 2022, and this time he designates the beneficiary as Lucy Primrose. So our question is, when Evan passes away, which deed is effective on this piece of property? Is it the TODD that was filed first on June 22nd, 2020 with Susan Primrose as the beneficiary? Or is it the transfer on death deed that was filed latest, most recently on March 25th, 2022 with the beneficiary as Lucy Primrose? Which one of those Tods is the valid one? And I'll give folks just a few seconds more to answer because this is a pretty cut and dry question. Don't forget to hit submit. Okay. Let's take a look at what our answers were. So it looks like most of you answered that the transfer on death deed filed in 2022 is the effective TODD, and you would be correct. The reason why is that if more than one transfer on death deed has been filed on the same property, the latest one is the one that is valid. This is because the transfer on death deeds are like a contract, they're a controlling document. So if you file one most recently, it overrides any previous ones on the same property. So, a Tuesday tip from the Evening Primrose, think of the Primrose family and make sure that you keep track of your transfer on death deed filings. It's possible that Evan intended to override his previous transfer on death deed, but maybe he didn't intend to. Maybe he didn't remember that he already had a beneficiary lined out for that one. So keep track of your TODDs and make sure that you update them as necessary.
And Emily, I could see this happening in a situation where the person is starting to exhibit some signs of Alzheimer's or some form of dementia. And you say, well, how could you forget about filing something? Well, if you've dealt with someone that has Alzheimer's, you see that the financial management and some of these kinds of issues start showing up sooner than a diagnosis would happen. So maybe this is something for you to help if you notice mom or dad are having maybe some issues about decision making. Now, what about a will and a Todd? Well, the blue flax is the one that I decided to include for this one because I'm talking about Gary Blue and his two blue children. We've got Linda Blue, we've got Matt Blue, and what Gary has done is he's filed a transfer on death deed and he has named Linda as his designated beneficiary. Well, later, Gary writes a will, and what he's doing is leaving the same property to his son, Matt. Now, you know what Emily and I are going to ask, don't you? All right. Yes, yes. Who gets that property when Gary Blue passes away? Is it going to be Linda Blue because she's the designated beneficiary, or is it going to be Matt because remember that will was written the most recent? So give me your answer and don't forget to hit submit. Gosh, Emily, it's so many months since I've used the clickers. I wonder if I'll remember how to do that. Because this is what I used to do with public meetings, is I had these little machines that I passed around to people, and everybody could click their answer. We'll do that again someday. You just wait and see. Okay, what's our response here? Emily, let's see what the majority of the people said. Oh, my goodness. We have some disagreements here. We've got 32 of you said Linda. We've got 26 of you that said Matt because you fell for my example there. There we go. It is Linda. You see, a will cannot undo this contract that you've done. So we need to be clear and we need to shout it from the rooftops to our relatives that when we write a will, we've got to make sure the will agrees with these other kinds of things that we've done. And in this case, Gary has already filed the beneficiary deed saying Linda's going to get it. And poor old Matt, he gets 0. And of course, Matt is going to tell Linda, hey, Dad wanted me to have that. You know, that was the most recent thing. But no, that's not going to happen. And a matter of fact, what we've got is Matt is singing the blues. Okay, can you imagine the holidays in a situation like this? Matt is mad at Linda. Linda says, Dad wanted me to have it, obviously. And I don't see them getting together for Christmas and Thanksgiving. You know, regardless of when COVID gets finished, I don't think that these people will be getting together. Now, it could have been Gary would decide he's going to refile. And what he does is name the Alzheimer's Association, the Montana chapter. And I'm throwing that in there specifically. When you are going to recognize sort of a national organization, you've got to make that decision. Do you want it to be national or do you want it to be within the state of Montana? We actually had a case this past year where a gentleman in Butte passed away and he left it to, and I won't pick on the organization, but let's just say it was one. And everybody knew he meant Montana, but he didn't say so in the will. So what you've got is the national organization saying, hi, it's our money. Well, anyway, back to this story. Now we've got Matt and Linda singing the blues. So you can't undo a transfer on death deed with a will. You know, it doesn't matter when that will was written, before it or after it. It's the transfer on death deed is a separate, think of it as a contract, like the joint tenancy. So as I look at the clock, my observation is this lady slipper is saying, Marcia, time has slipped away. And I hope I did steer you to consider a transfer on death deed as a way that you can transfer your property and avoid the cost of probate. And if you don't have a memory like this elephant's head, isn't that one cute? Don't you see the trunk and the little ears that are there? Yep, it's Grandma's story about an elephant and memory. We do have those 46 monk guides that are available to you. They're at this website as well as our Tuesday tips. And we also have those available from our county extension and reservation offices. So we really do appreciate your being here today. And like I said, we're going to hang around and answer some questions that you might have. And next week, no, yes, no, I didn't give you the right program for next week. I apologize. See, I'm getting Tuesday tips and Mock Guide Mondays mixed up. I'm sorry. But anyway, stay tuned, at least on the January the 25th. We're going to have a guest presenter by the name of Joel Schumacher, and he's done some work in the long-term care insurance area. So he's going to be talking about that while I'll talk about some of the Medicaid issues there. So we'd appreciate sharing any thoughts that you have about the webinar. And I think Emily's going to pull up some example questions that you could answer for us. And we will leave those up for a little bit. And in the meantime, while people are filling that out, and don't forget to pull down on the right-hand side, there's 3 questions and you need to type in an answer. Do we have any questions at this point in time, Emily?
Yeah, we do, Marcia. Did you want to stop sharing so that you can, so they can see your whole face?
I'll do that. I was afraid I would eliminate the share thing there.
I think we should be okay. Yeah.
Okay.
Fine. Okay.
I don't see it anymore.
We did have some questions come up in the chat. Some of these were asked during the presentation and you probably already answered them, but just to reiterate, can you have more than one primary beneficiary?
Yeah, you can have as many as you want. Just keep in mind, let's say that we've got 4 people and we're leaving those, we're transfer on death deed, the lake, the cabin at the lake. And can these 4 people get along? And do we have situations where we might have property taxes and other things that some of them really aren't as financially well off as one of the other kids? And so in a case like that, we might say, well, we don't want to do a transfer on death deed. Maybe what we want is a testamentary trust. And we leave the property in the trust to the 4, but we also have a separate trust that we put money in to take care of paying the bills. So I'm not saying a transfer on death deed is for everybody. That's why it's good to go to an attorney and get some sense of your specific situation.
Okay. Another question that's related that I believe you answered as well. Can you have more than one alternative or successor beneficiary, for example, 50% to each child? And I believe, yeah, that was like
same thing with 2 nonprofits. If you wanted to, you could mention MSU and U of M, and they split equally.
Okay. Another question came up when we were talking about Pat, how he had written the TODD and listed his brothers as the beneficiaries. And then he had the Montana 4-H Foundation listed as the successor beneficiary. They asked, shouldn't Pat have rewritten the TOD if both beneficiaries died while he was alive? And I suppose my response to that would be he certainly could have, but it's possible that after his brothers, he maybe didn't have anybody else he wanted to leave it to, so he could have just left it and then the 4-H Foundation would receive it and there wouldn't be an issue.
Yeah, he would, if he was going to do that, I think the cost of filing is $17, depending on how many pages you've got. And it would have been ideal. But it's ideal that everybody gets their will written, and we have 6 out of 10 that don't. So we're not always doing what we think we should. And of course, I've done it because if I'm going to preach it, I better make sure I do it. I don't want the headlines to read, Marcia Getting Specialist dies and didn't do any estate planning. Oh my gosh, I would be mortified. Okay, any others?
Yes, there's actually quite a few. Someone asked, if your children are minors, what is the best way to will them the value of the property in case both parents die? Okay, that sounds like legal advice to me. So I will take the educational approach. And the educational approach is, gee, if we have minor children, one alternative that we could do is have a testamentary trust. We could name a trustee
to handle the money for the children. We can write in there, what are the circumstances under which the children get the money? Do they have to go to school? What do you define as a school? Is it an apprenticeship in a plumber, or is it a college? So if you're thinking about that, it's very similar to writing a will and naming guardianship of the children and a conservatorship. If the children are minors, you can just, have this conservator, and that conservator will handle the money for the children. But with the conservatorship, the kids get it at age 18. Now, I don't know about all of us, but maybe we weren't as financially astute at 18 as we would be at, say, 25 or 30. So that's where the trust comes in, and you can say, I want to name this person or this company as the trustee, and they will make the decisions based on the directions that I've put in the trust agreement. Okay.
I would also let you know, the person who asked that question too, we will be talking about trusts during our Tuesday tips on February 16th. So that might be one you want to tune into if you have questions about that.
Now, Emily, how do you remember that? Do you have that out in front of you?
Yeah, I do have it in front of me.
Good for you.
Someone else asked if you could explain the inheritance tax implications of various ways to pass on property.
Oh, the inheritance tax. We don't have one. We do not have an inheritance tax in the state of Montana. We have not had one since 2001. Now, sometimes people get the inheritance tax and the federal estate tax mixed up. Now, the federal estate tax, don't worry about that one either. Unless you have more than $11,700,000, you can have that much and not have to pay any death tax. So that doesn't impact, 99% of us in Montana don't have to worry about the death tax. And those that do, believe me, they got enough money. They can hire those attorneys and do what they need to do to minimize taxes. But right now, at this point in time, 11,700,000, double that for a married couple. It's amazing.
Okay.
So it's not like the old days.
So on that note, we had actually a different person bring up that they have heard talk of the step up in basis being proposed to be removed. Can you explain a little bit of what effect that would have if that step up in basis is gone?
Okay, so we need to first define step up in basis for folks that have not heard of it before. And let's just take an example here and say you bought a home in the 70s for $50,000. Okay, and when you pass away then in 2022, that house is increased from 50,000 to, let's say, 500,000. Okay, so what it gets when it goes to the beneficiaries is a step up from 50 to, did I say 500,000? Okay, so it's stepped up in value. And if you sell the house at that $500,000, there is no capital gain tax on that. So the way that we've had it forever, except for 1 year, is step up in basis. So that allows each generation to transfer on to the next generation and the next generation. Each time we step up the basis. Well, we had a law some time ago, and they said, no, we're not going to do that anymore. We're going to do the carryover basis. And then they delayed it for 10 years. Well, I would talk about it at my estate planning meetings. And since it wasn't going into effect, people just kind of, don't bother us. Well, then it rolled around. And what you discover is, remember that $50,000 home? Well, okay, we carry over that $50,000 to the heir. Okay, so let's say this heir didn't sell it. and that person died. Well, we have a carryover basis again of 50,000, and now the house is worth $1 million. Well, nobody wants to sell it because they're going to have to pay a capital gain tax, or they may be forced to sell because they do it. So we've been down, in my humble opinion, we've been down this road before. And Congress felt that it was best that we always continue with the step up in basis. So I guess in some ways I shouldn't be surprised that it would make the roll around again, but it's the issue that people don't often understand what the difference is between carryover and step up. So that is a Mont guide that people have requested that I do something on that, because the information needs to be out there. So we'll see. I've also heard, oh, I told you 11,700,000. They want to go back to the old, and it's supposed to happen in 26 anyway, that we go back to the old days where the exemption was 3.5 million. So I'm sure we're going to see a lot of proposals, and there'll be a lot of gnashing of teeth and concern about it. So we'll see what happens. Stay tuned.
Okay, so another question. I was working on both a TODD and will this morning, and I wanted to name some contingent people to my son and daughter. Is it always best to do this in a TODD rather than a will? So they have two parts of their question, but that's the first question.
You know, I can't say what is best because I don't have a law degree. And there's more information that would be needed, such as an attorney would ask, to assure that the best choice is based on your value system and what you want to have happen with that. So either tool can do the job. It's a question of what do you want, what's the situation with the kids, and that type of thing. So I'd recommend the attorney examine that with you. We have attorneys that recommend Tods, we have attorneys that recommend wills, and we have those that recommend trusts. And so I think you should be in the driver's seat so that the attorney gives you the advantages and disadvantages. And then I would expect the attorney to help you with that decision and explain why. Anytime I hear a recommendation, I want to know, why do you think that's the best for me in my circumstances?
Okay. So then we have another question that kind of goes along with that. What happens if your beneficiary dies and no successor beneficiaries listed?
Okay, what the state of Montana is going to do then is go by the law of interstate succession. So we're going to look for relatives. Do you have second cousins, third cousins? They're going to go and try to find those people, and then those would be the ones that would inherit it as a part of the probate process. And you see, that's why we need a probate process, is when we have something like that, like a will, and nobody named alternatives or talk about the residue of the estate and who they would want to receive that. And so it goes under Montana law then. And Montana law says we're going to make the search for your relatives. And it's really sad when you have relatives that you haven't even seen during your lifetime, and they would inherit something. So, geez, find a nonprofit that you value and those people, unless you just want those long distance. Some people feel very strongly about bloodlines. I don't, but that's my bias.
Okay, so then another question regarding that. Can you name children who were not yet born or beneficiaries' spouses in the future as beneficiaries? So, for example, let's say they're not married now, but maybe by saying the legal spouse at that time.
Okay, when a will is written, one of the things that's in there that it talks about unborn children. No, and I'm kind of surprised about the spouse thing, because you may not want that spouse to receive the property, but you can say so, and maybe you've got one son that gets married 3 or 4 times, and but I would want to redo the will when we do a will, it's not something that's in concrete and it's supposed to last for the next 50 years. Now, if you have a situation, and I've certainly heard them from families, they don't like the daughter-in-law. Initially they thought, yay, but later, there's some things that went on. And so there was no way they wanted her to receive the property. Well, by God, they redid the will and she was left out. So you decide what seems to be best for your situation. But I could say the unborn children, hey, that's not a problem. And you can also disinherit your kids. Doesn't mean you're doing it in a nasty fashion. You may have one child that is very successful, and you have another child that is looking for extension or a teacher. It's not like they're just rolling in the dough, are we, Emily? So you got to take that in consideration too. Probably Emily is, and I'm not rolling in the dough. Okay. Any other questions?
So someone asks, if you are designating beneficiaries on a stock account, is that a type of POD or TOD?
We're going to be talking about those, but they're referred to as a transfer on death registration. So in other words, you have this stock that has your name on it. So if you're saying, I want, when I die, to have that stock registered in my son's name, John, for example. And so it does the same thing. It's just a different title that the legislature decided to use that. So it is kind of confusing, a TOD and a TODD. And they're both Todd, of course. But it's a little bit, it's nice to have that. And the stock receives a step up in basis too. So if you have something that was purchased at this price and now it's at this price and you sell it at that price, no inheritance tax, no estate tax, no capital gain tax. Thank you, Grandma. It does something like that.
Okay. Someone else asked, if you are only concerned about transferring property, do you even need a will, or is a TODD good enough?
Okay, if you're, see, the thing is, we can do PODs for checking savings, TOD for our stocks, bonds, and mutual funds, and then we could do a Todd for our real property. So we may think, we can do everything. Well, what if we forgot to do something? What if we had an account that we forgot? Well, that's where the will comes in. And another reason that I see for the will is you can have a paragraph in the will that says, I have a separate listing of tangible personal property. Now, these are the things that have emotional value in a family. And if you want to see families break up, it's often over those items. So by having that list, now separate from the will, here's our will, we have a separate list, but in the will, we've got the paragraph. So you name those individuals. And if you're a personal representative, you're relieved because you know who's supposed to receive those things. You don't have a knockdown drag out here with family members fighting over that gun that dad verbally said, I want you to have it and I want you to have it. If he has it in writing, we honor what dad said. And as I tell parents, let him be mad at you. Let the family continue and don't have your children going like this. And surely in your community, you've heard people where families aren't talking over those kinds of incidences. So that's why I still have the will, just as a backup in case I forgot something, but if nothing else, for that separate listing.
Okay, we have another, this one doesn't seem much like a question, but I think there is some clarification we need to do here. Okay. Someone says, if I already have a will, probate will be avoided anyway. So no TODD. Well, there's more to the question, so let me So no TODD needs to exist, except if I want to use a TODD to override a beneficiary designation in my will. So maybe some clarification on that.
Okay. First, a will. We think that once we've done a will, ta-da, it's legal. Well, it's a legal document, but it hasn't been validated. Okay, so we would go to probate to have the will validated. But let's back up. We had a TOD, we had PODs, and we had a Tod. So, gee, that pretty well covered it. And let's say in this will, we didn't have the separate listing. There are circumstances where an attorney would say, you know, we don't need to probate this will and go through that expense because there's no property subject to the probate. So that could happen too. If you take advantage of all these three methods that the legislature has given us, and that was part of their purpose, is to, you know, people have this bad concept about probate, but it's really something that's out there to make sure that legal heirs receive the property they're supposed to. And in Montana, it's not like California and New York. Oh my goodness, their fees are high. Montana's pretty simple. And now probate fees are reasonable. And I'm writing a mock guide on that because what is reasonable when it comes to a personal representative? What is reasonable when it comes to attorney's fees? See, before I could tell you it was 3% of the first 40,000 and 2% in excess of that. And all of us could calculate that. But you would get that even if there wasn't that much to do. So the attorneys felt it should be based on the term reasonable. And I'm in the process of collecting examples of what attorneys feel is a reasonable fee. I want to be able to give you some information about that. Okay, so I hope I clarified that. And if you say that was as clear as mud, Marcia, email me and we'll discuss it maybe over the phone or something. But I'd be glad to visit with you.
Okay, so there was a question that came up specifically about probate costs. So they were just asking if you could explain that a little more. You sort of did there at the end. Is there anything else you would add? I mean, to someone who's asking to explain what probate might cost?
I got calls after that law passed about, well, what is reasonable? And I went, duh. So again, that's why I'm working with a group that's called the Business Estates Tax Trust section of the State Bar, so that we can provide some more guidance on that, because right now we don't have it. And I think they thought this was such a good thing, but that was my first question. What's reasonable?
Right. Okay.
Okay.
Someone else is asking, when you leave more than one beneficiary of property, such as a house, in joint tenancy with right of survivorship, are there any restrictions to them selling the property?
No, once you have it, Emily, you and I have property in joint tenancy, and I die, zoom, it goes over to you, and you decide what you want to do with it. You can sell it, you can give it away. Your surviving joint tenant can do what they want to with that property. So if you have strong feelings about that, then maybe we need to look at, should our property be in joint tenancy? Should we have it another way where the both of us could agree how much control we want to have over the future? And there's not much that we can control about that, but we can make some additional ideas.
Okay. So then I guess too, on that note, let's say that a house is left in joint tenancy to two sons. Could one, they would have to agree that they wanted to sell the house if both of the sons are still alive, right? One could not sell it out from under the other one.
Yeah, technically what can happen is you've got the two, and if they're in a real disagreement, what one would probably do is go to court and say, let's have the court put this as a tenancy in common. We're going to, quotes, divide the interest. Okay. Well, that means then, Emily, if you and I did that, you could then put your interest up for sale. But who's going to want to buy that property and be with me? they don't like me. I do weird things, whatever. So that's what can be done, but it gets pretty sticky. So usually, for the good of the family, one or the other gives in, and it gets sold.
Okay, so that maybe answers this next question that's asking, what if there are multiple beneficiaries that don't get along and only one of them wants out?
Yeah, and if one wants out, maybe the rest could agree that we're going to buy him out. But yikes, with the price of land in Montana the way it is right now, that makes it pretty tough to do. But it could be an alternative. People, the four that are left may feel strong enough about it that they say, okay, let's all put up something and let's get rid of this one. And then sometimes you have some kids that say, I don't care. I don't even want to be involved. I know. I don't want to be involved with it. I don't want to have this fight, and just go. It just depends on the family.
Okay. Someone's asking, do all TODDs need to be filed with the county, and do you need an attorney to file it?
You may want to have the attorney do your transfer on death deed. And a part of his service would be that he would file it. On the other, or she. On the other hand, you could say, if you'll just do the paperwork, I'll go file it. Because his time is worth probably more money than mine is, and so I would take it and do it myself.
Okay.
And just keep a copy.
Are those always filed with the county?
County clerk and recorder. That's where you do it. And you may find that your clerk and recorder, sometimes your clerk and recorder can't give you legal advice. Okay, just like me. But we had some that were accepting beneficiary deeds, and they turned away a transfer on death deed. And that was unfortunate. And we got that situated out because it is transfer on death deeds now, not beneficiary deeds.
Okay. So someone is asking that question about Faye and Ray, when we had Pat, Faye and Ray. Upon both of their deaths, if there was not a successor beneficiary named, so let's say that Pat did not name the 4-H Foundation, would the property have gone to the state, or where would it have gone?
We would still look for those additional relatives. We know that there were some, or there could have been, those people had children, so it would end up going to them. And it would make a difference if there was one kid versus 2 kids in the shares. But you can go to Dying Without a Will and look at the situation and answer those questions, and that'll tell you where that property is going to go. We keep pretty close to an immediate family, but they'll go out there and find second cousins and that type thing, because those are your relatives.
Okay. So someone is asking, with the TOD, what happens to the contents of the property? So if this person is still on, if you maybe want to clarify what you mean, I'm not sure if they mean the house that's sitting on the property or the things that are.
They're probably talking about the stuff that's on the inside.
Yeah.
And see, that's where the will comes in. If you haven't got a will indicating what's happening to these things on the inside, then what we've got are, say, the 2 heirs that receive it. So they come and they look at what's there and decide, well, how are we going to divide up those things? Are we going to have an estate sale? What are we going to do? They have to have some sort of agreement, because you don't have a personal representative appointed to make sure that that gets done. You have to do it on your own.
Okay. Someone else asked, scroll down a little bit. I'm trying to advise my children in their 30s who also have children to make future plans. What is the best advice I can give them, because they're busy and it's easy for them to procrastinate? You can't give legal advice, but.
Yeah, and if those children have minor children, one of the mock guides that you could give them is the estate planning for parents with minor or special needs children. And that might help get the conversation going. But you could also say, I've done this because I want to make things easier for you. Now, if something would happen to you, don't you want to make things easier for us? And it's a process. It's not something that, oh, you go to a webinar and all of a sudden you're going to do everything. Although there are people, I'm glad we got them excited about it, happen. So it's a process. Oh, did I show you my, here's another idea. This is something you could give the kids, and what is inside are ideas for doing their own estate planning. And so we've got Valentine's Day coming up, and you could make one of these for the kids, and you put the little notes in. We've got one at our website that shows, do a will, get the Mont Guide on the children. But if they're busy anyway, you can order it and have it sent to them from our extension offices or our mail. It's not mailroom anymore, it's publication office. Okay. And I must say, I'm sure some of you need to go somewhere. We're over time, and we're glad to do that, unless you have a meeting, Emily. But if you do need to leave, that's okay too. And I just want to say thank you very much. We'll look forward to seeing you next Tuesday, the 19th. Oh, I can't hear you, Emily.
I forgot to mute myself. We do have a couple more questions. Are you okay with staying on a few more minutes, Marcia? People, okay. So yes, if you haven't had your question answered yet, you can certainly stay on, but you, of course, do not have to. Another question that came up is a beneficiary of a trust taxed?
Okay, first of all, we need to take a look at trusts. Trusts are taxed as if we have a revocable living trust, the taxes on it are the same as we have, as long as those people are alive, the trustees. And then later on, depending on what kind of trust we have, we still have a tax. So there's the income tax, and that's what we would be looking at. There would be, maybe if the trust sold some property, there would be a capital gain, and so that would go in, that would be a part of income to the trust. So yeah. The only thing certain about life, what is it? Death and taxes.
Someone is just clarifying, is the step up in basis a federal policy so that, if someone has a home in Idaho or Ohio, that would still apply?
Yeah, it's across the nation, the step up in basis. And typically what happens in these kinds of cases, the state says, we do the same thing as the feds do. And so, see, the thing is, we could say there's no inheritance tax and there's no federal estate tax. But if we don't have a step up in basis, this capital gain tax could affect anybody that sells a house. Before you wouldn't have had to worry about it. Well, now, and true, we do have some situations where we get an exemption for some of the house. But let's say it was some other, like the stock. Well, there's no exemption there. So the stock was here, now it's there. So we need to know the difference between carryover and step up.
Okay. Someone's asking, should my IRAs be put into I think they just said TOD, so just transfer on death, or should I just have beneficiaries? I don't recall TOD as an option. My IRA just has my 2 children listed as beneficiaries.
Yeah, and that's fine. See, that's the thing. Many of us did our beneficiary designations years ago on our IRAs and things like that. And they weren't called transfer on death registrations. They were just beneficiary designations. And the issue was in Montana, we had companies doing business, selling stocks, etc. And they were saying, if you're going to do that, you need to offer an option for beneficiaries. And there were some that were not doing that. And I've got one I'm dealing with right now. What do you mean you don't have a beneficiary designation? So we'll see what happens there, because they have to. Okay.
I think this person asked this question before you answered it before, but for a TODD, does property include what's inside the house? Does it include cars, campers, etc.? Does that need to be listed in a separate?
No, it has to be real property. And the property inside the house is personal property. And the same way when you got a car and but I'll just throw this out. One of the things that's going to be introduced this session is the equivalent of a POD for our vehicles. stay
Okay.
tuned if that one passes.
That's good to know, because the next question was actually, can you do a TOD for vehicles?
Not yet.
There is a Mont guide though, right, Marcia, about transferring titles after death?
Yeah, the Department of Justice is the one where we have the motor vehicle division, and they have a somewhat simple form for the vehicles. So one of the Mont guides that it wrote was on how to deal with your vehicle, and if it's in joint tenant, well, I say if it's either solely owned or joint tenancy, they do not accept tenancy in common on vehicles anymore. If there's more than one name, that's automatically a joint tenancy with right of survivorship.
Okay, so I did put the Mont guide for the vehicle transfer in the chat. If that person is still on, you can just click or copy that link to follow it. I think those are all the questions that have come up.
Okay, great, Emily. You can go and copy that in really fast. This is why she is my tech buddy. That's great. Well, again, I just remembered I'm supposed to get my computer fixed at 11:15, so I better get on and get off of this. So thank you for joining us this morning. Emily and I look forward to seeing you next week. Have a good week in the meantime.
Yes, thank you. Bye.